Okay, so we're going to now go on to Kerri Bruss, and Kerri is a retired nurse, proud mother of two, lifelong feminist. She's an active volunteer with WDI USA and wears many hats, serves as the US country contact, and she served on the original steering committee. While a member of the steering committee, Kerri did much of the conceptual heavy lifting behind the organisation's Equality for All Act, EFAA, intended to be an alternative to the egregiously misnamed US Equality Act, which, if passed, would significantly harm women, children, lesbian, gay, and bisexual people by adding gender identity to the list of protected characteristics in US civil rights law. Thankfully, that bill appears to be dead. Since then, Kerri has stood up with and for women in boots on the ground actions across the country, has been involved with the grassroots organisation of WDI USA. I'm going to guess it says such events as the such events. In 2022, she was the lead organizer of the Midwest segment of the global prison protest held on International Women's Day in Chicago, which also promoted D-Trans Awareness Day, contributed to the organization of Sisters for Sisters weekend held in Madison, WI, and was one of the three women who organised the Chicago portion of Kelly J. Keene's Let Women Speak US tour.
It's an honor and a pleasure to be here to present an update from the US in the context of our shared efforts to defend the sex-based rights of women and girls and to ensure that our children are safeguarded from the harms of gender identity ideology. But first, I'm going to share a bit of relevant background. As I'm sure you're aware, the US is a vast country comprised of 50 states, the District of Columbia, and US territories. As was mentioned in the US Country Report, included in WDI's book, Women's Rights, Gender Wrongs, federal law is created at the national level and is informed by the US Constitution. State law exists in parallel to, and sometimes in conflict with, federal law. Where there is a direct conflict, federal law generally prevails, except where state law affords residents additional rights when that is presumed to take precedence. As a result, almost all legal decisions are open to interpretation and legal challenge. Complicating matters even further, as the report also references, in the US legal system, executive orders carry the weight of legislation without being law. They are a way for a president to enforce his or her will on specific issues where legislation would be unlikely to pass in Congress and can be undone at the stroke of a pen by a subsequent president. On his first day in office in January 2021, President Biden signed an EO redefining sex to include gender identity throughout federal administrative law. As a result of this EO, and a series of other such measures the Biden administration has subsequently issued, legal rights and protections intended for women and girls are now broadly accessible to any male who claims a female identity. Resistance to these challenges are currently playing out in state houses and courts all over the country, which brings us back to the more recent updates portion of this presentation. While by no means a comprehensive review, I'll touch on significant or interesting developments that have occurred over the past few months to give you an idea of how our shared goals are progressing here in the US. With regards to Article 9 of the Declaration, our report documented that children can be recognized as the opposite sex socially and be subjected to puberty blockers, wrong sex hormones, and gender assignment surgeries, although rules vary from state to state. According to data compiled by the Movement Advance Project, 24 states have now passed laws restricting or banning the medicalization of minors, though many may not be in effect yet, primarily due to legal challenges. While the decision to overturn Roe has abolished the constitutional right to abortion, the state-by-state battle for abortion rights is far from over. Since Roe was overturned in 2022, 14 states have enacted near total abortion bans, while 2 have banned abortion past roughly 6 weeks of pregnancy. Other states have enacted laws or held ballot referendums to protect abortion rights. In a handful of other states, the future of abortion is in flux. Mine is one of them. The Center for Reproductive Rights has published a handy resource titled After Roe Fell, Abortion Laws by State, which is updated in real time. Anyone interested can click through this tool to learn about all the bans and restrictions currently on the books in each state. On January 24th, the Ohio Senate voted to override the governor's veto of the SAFE Act, a bill that bans the medicalization of minors and protects single-sex sports. Within a week of the override, ACLU of Ohio announced its intent to challenge the law. The suit filed on March 26 asked the court to strike the law down before it is scheduled to take effect on April 24th, and specifically targets the law's medical care restrictions. On January 24th, Redux broke a disturbing story out of New York, reporting that a former female inmate was suing the city after being repeatedly sexually assaulted by a male inmate who had been housed in the women's section of Rikers Island. The inmate says she was subjected to repeat abuse by the man, who was permitted to stay in women's protective custody after being instructed by Department of Corrections staff to claim a trans identity. Worse, according to the suit, DOC records show that at the time the male entered the women's housing unit, he was being investigated for potential involvement in a prostitution ring operating within Rikers. The ring involved staff and inmates, and the DOC was reportedly aware that he was likely moved to the female unit to facilitate his procurement of female inmates to pimp out to male inmates and staff. And that's a quote. Under the Protection of Women in Olympic and Amateur Sports Act, a bill introduced to both houses of Congress on February 1st, governing bodies recognized by the U.S. Olympic Committee would be prohibited from allowing men with a woman identity to participate in any athletic event intended for females. The bill also modifies eligibility requirements for amateur sports governing organizations. On February 2nd, the New York Times published a comprehensive investigative piece about detransitioners titled, "As Kids They Thought They Were Trans, They No Longer Do," that applies much needed scrutiny to the gender affirming model. The author, Pauline Paul, also published a brief follow-up piece titled, "The Courage to Admit You Don't Know," addressing common claims from those who favor the current treatment model that very few people detransition. Of note, Elizabeth, our chief of staff, wrote a letter to the editor in response to Paul's piece that the New York Times published on February 10th. This marked the first time WDI USA has been published in the Times, and we, not to mention Elizabeth, are quite pleased about it. On February 5th, Redux broke another disturbing story, this one out of Montana, in which a family accused the state's Child Protective Services of kidnapping their troubled 14-year-old daughter after she began to identify as a boy, a social transition they did not support. Krista and Todd Kolstad spoke to Redux about their ordeal, revealing that the child initially had been temporarily removed from their care as a result of their failure to affirm, but that Montana Child and Family Services has since petitioned the court to transfer custody to the child's long-estranged biological mother in Canada. Additionally, the parents are reportedly facing arrest after speaking to the media after having been ordered by a judge to remain silent. Also on February 5th, the Free Press published a piece about another gender clinic whistleblower who has come forward, this one from Tacoma, Washington. Therapist Tamara Pitsky tells how she could no longer go along with the pressure to transition her patients, even those with extreme vulnerabilities and comorbidities, without any examination of the root cause of their distress. At the time her story came out, Tamara had left her job at one of Washington State's biggest hospital systems and was just 3 weeks into her new one. Mere days after publication, her new boss requested her resignation. Tamara believes that publicly sharing her opinions about youth gender medicine contributed to her firing. In Massachusetts, on February 8th, the girls' basketball team of Collegiate Charter forfeited at halftime against Kip Academy because the team included a 6-foot-plus tall male player who the coach felt was causing injuries to his players repeatedly. Of course, the inclusion of a male player with a female gender identity on a girls' team is consistent with MIA rules. On February 14th, a bipartisan group of lawmakers introduced a bill that would establish a task force to examine the conditions and experiences of Black women and girls in America. Unfortunately, the Protect Black Women and Girls Act includes language that defines those women and girls as individuals who identify as a woman, female, or femme. On February 19th, Reem Al-Salem, UN Special Rapporteur on Violence Against Women and Girls, publicly released her letter to the US government regarding the proposed rule changes to Title IX and the potential negative impact that its revision could have on the participation of most women and girls in sport. It's definitely worth a read in full. Quoting from an article published in the Washington Free Beacon on February 21st, legislation introduced last week by Democrats, which refers to pregnant women as birthing people and non-binary persons and persons of transgender experience, whatever that is, would require anyone involved in maternity care, from hospital cleaning staff to doctors and nurses, to undergo semi-annual training to undo their multiple layers of potential biases, that pregnancy and childbirth are female experiences. The article includes quotes from Kara in opposition to the bill, as well as from Cynthia Cravens, a California Democrat and then candidate for state Senate. Cravens was running to unseat incumbent Senator Scott Wiener, the politician responsible for many of the anti-woman and children bills that have become law in California. Sadly, she lost her primary in March. I'd also like to mention the ongoing statewide ballot initiative proposed by Protect Kids California, an organization advocating for policies that promote all children's rights and well-being. If enough signatures are gathered by May 15th, the initiative would require schools to notify parents regarding children's mental health concerns identified in school settings, including gender identification issues, protect girls' sports and spaces, and prohibit puberty blockers, cross-sex hormones, mastectomies, and genital surgeries for minors. Wish them the best of luck out there. Also in February, Democrats in the state of Illinois introduced a bill that would change the definition of abused child to include a parent who denies their child gender-affirming services, which per the bill falls under the heading necessary medical care. Fortunately, the bill is dead, for now anyway. Apparently, it was not advanced out of the Rules Committee, so did not get a hearing in the full House this legislative session. On February 21st, Kara tweeted about a big win for free speech in US schools and the material reality of sex. The case she is referring to is Parents Defending Education versus the Linn-Mar School District in Iowa, which recently was resolved in a settlement agreement after PDE prevailed in the Eighth Circuit Court of Appeals. Linn-Mar agreed to rescind and not reinstate the portion of the policy that prohibits an intentional and or persistent refusal by staff or students to respect a student's gender identity. Moving on, continuing a legal battle that began with the nationwide reversal of Roe, Planned Parenthood of Wisconsin filed a petition urging the Wisconsin Supreme Court to protect the right to abortion. The organization is asking the court to answer this question. Does the Wisconsin Constitution protect the right to access abortion care and a provider's right to provide abortion care? This is all well and good. However, not once does Planned Parenthood's petition refer to women, the only Wisconsinites who would ever have need of an abortion. In an article published by the City Journal on February 27th, titled Stacking the Deck, Leon Sapir writes, the U.S. Endocrine Society is updating its clinical practice guidelines on gender-affirming care. ES, however, appears to be putting its thumb on the scale in favor of medical interventions by appointing experts with serious conflicts of interest to its guideline development group, ignoring its own standards for how to write trustworthy medical recommendations and trying to keep the process hidden from the public. Sounds familiar, doesn't it? Excuse me. Also on February 27th, the Seventh Circuit Court of Appeals confirmed that it has overturned a federal judge's June decision blocking Indiana's SB 480. This means that the state's ban on the medicalization of minors is now allowed to take effect. On March 8th, Next Golf announced, and I quote, a significant update to the eligibility policy for the Next Women's Pro Tour. Effective immediately, competitors must be a biological female at birth. Sorry, it's a quote. The decision underscores the organization's commitment to maintaining the integrity of women's professional golf and ensuring fair competition. The Free Press recently published a story that could have huge implications for women's sport in the US. 16 female athletes are suing the NCAA over its discriminatory policies that allow men to compete as women, in violation of their rights under Title IX and the Constitution. The lawsuit seeks to change the rules, rendering males ineligible to compete against females. It demands that the NCAA revoke all awards given to male athletes in women's competitions and reassign them to their female contenders, and also asks for monetary compensation. Icons, founded by FQT's mother of swimmer Kim Jones, has announced exclusive funding support for the lawsuit. Congratulations are in order to the state of Wyoming, whose legislature passed the Children Gender Change Prohibition Bill on March 14th. The bill, formerly called Chloe's Law, after detransitioner Chloe Cole, bans the medicalization of minors in most situations and also allows for various medical boards to revoke licenses for nurses and pharmacists who break it. Next, I'll speak about an interesting situation currently unfolding in New York. In late February, Nassau County Executive Bruce Blakeman signed an executive order prohibiting male athletes from competing against girls at all 100 sports facilities run by the county, effective immediately. This prompted New York's Attorney General, Letitia James, to send a cease and desist letter calling the ban discriminatory and transphobic. The decision sparked heated public debate and several lawsuits against Nassau County, the most recent one by the New York Civil Liberties Union. To his credit, Blakeman is standing firm. It will be interesting to see how the situation plays out, particularly if other counties opt to take similar action. A 13-year-old middle school boy who identifies as a girl has filed a federal lawsuit against the Elkhorn School District in Walworth County, Wisconsin, for denying him access to girls' restrooms for the past 2 years. The complaint alleges the Elkhorn Area School District violated his rights under Title IX and the 14th Amendment of the Constitution. The boy apparently finds the district's gender support plan, allowing him access to faculty restrooms for the past 2 years, unsatisfactory, as he wishes to be treated like every other girl at school. The Minnesota Court of Appeals has handed a win to USA Powerlifting in its fight against J.C. Cooper, a man with a woman identity, by sending the case back to the lower court. Last year, the district court ruled that USAPL violated the Minnesota Human Rights Act by excluding him from the women's division in 2019, asserting that the organization does not have a legitimate, non-discriminatory reason for its decision. The appeals court rejected that argument, concluding that USAPL's assertion that it excluded Cooper from the women's division because his male physiology gave him an unfair advantage over athletes with female physiology is a non-discriminatory reason. On March 26th, the U.S. Supreme Court heard oral arguments over whether to limit access to the abortion drug mifepristone nationwide. The federal lawsuit was originally filed against the FDA in November 2022 on behalf of a coalition of physicians who oppose abortion. In response to the federal court's injunction pausing FDA approval, the Department of Justice filed an appeal seeking an immediate stay of the decision. The appellate panel then issued a complicated ruling on the injunction, siding in part with the FDA and part with the anti-abortion coalition. The decision allowed partial access to the drug while the federal case played out, but with new restrictions on how it could be dispensed. The ruling led the DOJ to appeal to the Supreme Court in hopes of fully restoring access to the drug. Ultimately, the Supreme Court granted a full stay, while the legal challenges to the lower court ruling restricting access continued. The 7-2 decision preserved the status quo, at least for now. And here we are. The Supreme Court decision is unlikely to be issued before the end of June. In yet another breaking news story, Redux reports that a woman incarcerated at the Women's Correctional Center in Washington State has come forward with allegations of having been sexually assaulted by her cellmate, a man who was transferred to the women's prison in 2021, and whose criminal history includes sexual offenses and violent assault. The female inmate, known only as Mary, reports that she became increasingly uncomfortable with Christopher Williams' behavior towards her, which had a near constant sexual undertone, and progressed to include threats of sexual violence, the presentation of strap-on dildos with a request that she use them on him, and touching her in her sleep. After Mary's PREA report was determined to be substantiated, Williams was taken into segregation and eventually moved out of her cell. However, she reports that his intimidation of her has continued. On April 2nd, as expected, Wisconsin's Democratic Governor Tony Evers vetoed a bill banning male high school athletes from participation in female sports. Representative Barb Dittrich, the bill's lead author, blasted what she called Evers' misogynist veto and claimed the governor once again stands against women. Sadly, Wisconsin Republicans likely don't have enough votes to override the veto. Late last year, Evers also vetoed a bill that would have banned the medicalization of minors. Okay, at least 20 states have approved a version of a blanket ban on male athletes playing on female K-12 and collegiate level sports teams statewide. But a Biden administration proposal to forbid such outright bans is set to be finalized this year after multiple delays and much pushback. As proposed, the rule would establish that blanket bans would violate Title IX, the landmark legislation enacted in 1972. The claim is patently absurd, considering that Title IX prohibits discrimination on the basis of sex, not gender. However, it appears the Biden administration may be getting election year cold feet about finalizing at least some of the proposed regulations. As even the Washington Post is forced to admit, these policies are not popular with Americans, and polling consistently demonstrates that clear majorities, including a sizable slice of Democrats, oppose allowing male athletes to compete on girls' and women's teams. And finally, I'm pleased to announce that WDI USA has filed a friend of the court brief in a case called Olympus Spa versus Armstrong. At issue in the case is the ability of a female-only nude spa to exclude men. A man named Haven Wilvich had been excluded from the spa and brought the spa before the Washington State Human Rights Commission. He won, and the spa fought back by filing a federal lawsuit. In its order dismissing the spa's complaint, the district court for the Western District of Washington repeatedly used the phrase transgender women with male genitalia, uncritically and without explanation. The case is now before the Ninth Circuit Court of Appeals. As we say in our brief, it is truly a testament to where we are today as a society that it must be said in the context of federal civil rights litigation that women don't have penises.